Hi everyone and welcome to Law Seco's brand new series on learning the law. This is a quick video on Introduction to Code of Civil Procedure, and you can find the entire notes of the topic by visiting our blog Hype Leaders, link to which is given in the description blog below. So आइए law सीखें. There are two fundamental categories law is divided into which. The first are the substantive law and second the procedural law. The substantive law determines rights and liabilities of parties, whereas the procedural law describes the enforcement of these rights and liabilities. Let us understand this with an example. Let us take Indian Contract Act. Indian Contract Act lays down the provisions and the basic principles of contract and bailment and other forms of special contracts too, whereas the procedural law of Code of Civil Procedure gives a key for enforcement of these rights and liabilities. Let us understand the history of the code. The history of the code starts with 1859, where the first Code of Civil Procedure was enacted. Before 1859, there was no uniform procedural law for civil judicature courts, whereby the procedure relating to civil rights could be enforced. Post 1859, we have another code in 1877 and 1882. However, these codes have their shortcomings, and finally, we got our CPC, which we have right now in the year 1908. The year 1951, 1956, 1976, and 2002 are four major landmarks shaped the foundation of CPC which we have today. There are three basic principles or the founding stones on which the entire civil procedure code is based. The first is a litigant should get a fair trial in accordance with the accepted principles of natural justice. The second is every effort should be made to expedite the disposal of civil suits and proceeding so that justice may not be delayed. The third is the procedure should not be complicated and should, to the utmost extent possible, ensure a fair deal to the poorer section of the society. By reading the preamble of the Code of Civil Procedure Code, we get it is a code to consolidate and amend the laws relating to civil procedure of the courts of civil judicature. As discussed in the very beginning of this introductory lecture, that in the earlier time there were no uniform code or procedure which could decide the civil matters, and it caused a lot of miscarriage of justice. And by the code of 1908 we get a consolidated form where the rights and liabilities, or perhaps the civil rights and liabilities, could be imposed in a uniform procedural way. Let us take a look at the scheme of the code. The scheme of the code is divided into two portions. The first are the sections and second the orders. There are 158 sections and 51 orders. The section deals with the provisions of a substantive nature. So the sections are called the substantive part, whereas the orders are called the procedural part, which corresponds to the section. Now, special provision is that the High Court have the power to amend the orders, but not the sections, which can be only done by the legislature. Now we'll take a look at the code at a glance. The first part discusses important concepts such as place of suing and res judicata or res sub judice, which is almost asked in every question paper, either it is law school examinations or judicial services examinations, or any, perhaps for that matter, any competitive exams. The second part, from sections 36 to 74 and order 21, covers execution proceedings. The principles governing execution of decrees and orders are dealt with section 36 to 74, which is the substantive law, and order 21, which is the procedural part of it. Now, section 21 is perhaps the longest order of the CPC, and it covers 106 rules. We have part 3 of the CPC dealing with formation of commission. We have part 4 along with part 5 laying down procedure for suits in special cases such as suit by or against the government or public officers, or suit by or against aliens, foreign rulers, ambassadors, envoys. The next important part is part 7 and part 8 of the CPC, as it deals with provisions for appeals, reference, review, and revision. Next, we have part 10 from sections 121 to 131, which enables High Court to frame rules for regulating their own procedure and the procedure of civil courts subject to their jurisdiction. And finally, we have part 11, which deals with miscellaneous provisions. For example, 132, which says exemption of certain women from personal appearance. Thank you, everyone, and we hope that you like this session. Notes on the topic Introduction to CPC is provided at IP Leaders blog. Link to which is given in the description blog below. Thank you very much.